Hey everybody, welcome to another episode of Foreclosure Help 777. Sue your lender, fight foreclosure and mortgage fraud. This is my Facebook group. You're welcome to come and join us if you have questions about fighting your bank if they're trying to foreclose on you. We have lots of us, we are very knowledgeable and can give you a lot of remedies and suggestions on your case. Maybe you should have an attorney, maybe it doesn't matter, or whatever, but we will go over a lot of things in our group that will be very helpful to you. So today we're going to talk about a problem a lot of us are having, the non-judicial foreclosure, how to fight a non-judicial foreclosure in court. So what does that mean? That means that they will come and just sell your house if you're in a state that's a non-judicial state. And they will typically, when you default on your loan, they will send you a letter in the mail about 90 days ahead of time telling you that you have to cure this or you're going to lose your house. And then they will send you other letters when you're getting closer to that date. And they don't have to file anything in the court to sell your house. They just file a notice of trustee sale. And so if you're at the point where they filed a notice of trustee sale and you don't have any time to waste, then a lot of people do go to an attorney to file bankruptcy, which will stop it, or they will file a temporary restraining order, or TRO, and preliminary injunction. And today we're going to talk about what a TRO is and how you can do one yourself if you don't want to hire an attorney to do it for you. Okay, so let's look at this real quick. So if you need to file a temporary restraining order, a preliminary injunction, and a permanent injunction, these are the things that you're going to need to know. Okay. Your application for a temporary restraining order, TRO, must convince the judge that you will suffer irreparable injury if the judge doesn't stop the foreclosure immediately, because you will lose your home if the foreclosure is allowed to proceed. Most courts accept that a foreclosure causes irreparable injury. TROs are typically granted without a formal notice or hearing, meaning the foreclosing party may only have a day or two of notice to prepare a response. If no response is filed, the judge might grant the TRO but require you to post a bond to protect the foreclosing party from economic harm if you lose the case. A bond can be costly, assuming you can get one at all. You might be able to get the bond requirement waived if your income is low enough. The court may grant a waiver if any of the following is true. The delay required by the lawsuit will not cause unreasonable harm to the foreclosing party. The validity of your mortgage is in question. The foreclosing party's interest in pushing ahead with the foreclosure can be protected by some other method, such as by requiring you to make reasonable monthly payments during the lawsuit. Whether or not you'll be able to get the bond requirement waived depends largely if the court believes your claims have any merit. Okay, so the TRO will typically last until the date is set for a hearing on whether or not the court should issue a preliminary injunction, which would stop the foreclosure sale until a full trial on the matter can happen. Preliminary injunction. The court will review each party's paperwork at the preliminary injunction hearing. At this hearing, the court must decide whether you are likely to prevail if the case proceeds to trial, and the injury you would suffer from the foreclosure outweighs the injury that the foreclosing party is suffering by not getting paid. It's called balancing the equities. If the judge decides these issues in favor of the foreclosing party, the TRO will end and your motion for a preliminary injunction will be denied. While you're technically allowed to continue with your lawsuit, the foreclosure will likely proceed in the absence of a preliminary injunction. Your only remedy at this point, and it's a considerable long shot, would be to ask a higher court for an order called a writ, overruling the lower court's denial of the preliminary injunction. But if the judge decides these issues in your favor, then the judge will issue a preliminary injunction. The preliminary injunction may order the foreclosing party to take corrective action. For example, by issuing a new payoff statement and giving you a chance to reinstate your mortgage, or they might just simply keep the TRO in effect, or they might offer you a loan mod, right? Another thing you'll need to do is record a lis pendens. A lis pendens means pending lawsuit in your county recorder's office, and we'll go over what that looks like and how to do that too. Permanent injunction. Wow. Because it often takes a long time, a very long time, to bring the case to trial on a permanent injunction, getting a preliminary injunction is pretty much equivalent to a victory for you. Typically, the foreclosing party will either attempt to reach a settlement with you, like by giving you a loan modification, drop the current foreclosure and begin from scratch, or meet any conditions laid down by the court and then go back into court to ask that the injunction be lifted. The burden is on you to prove that the foreclosing party doesn't have the right to foreclose, like by showing it didn't comply with state foreclosure laws or the mortgage terms. You meet this burden with the documents you file, typically declarations or affidavits from you and various witnesses that establish the facts you believe entitle you to stop the process of the foreclosure. For example, if you contest the accuracy or legality of the fees of the foreclosing party requiring you to pay to reinstate the mortgage or other fees, you would attach a sworn statement to your application for a TRO or preliminary injunction setting out the facts as you know them. Now, you can make a sworn affidavit and have it notarized as well. That carries a lot of weight with the court. If the foreclosing party produces documents that contradict yours, you'll need to convince the judge at the preliminary injunction stage that you deserve to have the foreclosure put on hold until you can produce your full case at trial. Because most preliminary injunction hearings don't involve witnesses, your paperwork might have to carry the day. Okay, so this is what a TRO looks like. I used Word and created this document. The headings are pretty straightforward. At the top, you want to put the name of the court that you're putting it through. Any court in the United States in your county. So this does not go to federal court. This goes to your state court. So the plaintiff, or plaintiffs if you're married, is John Doe or Jane Doe versus your bank foreclosing. That would be the name of your bank, whether it be PHH Mortgage or Green Tree Servicing, Ditech, Wells Fargo. You guys know who I mean. Now, in the caption title is Petition for a Temporary Restraining Order and Preliminary Injunction. So the first line, it's double spaced as you can see. Comes now plaintiff John Doe in pro se capacity files this emergency petition for a temporary restraining order and preliminary injunction against the defendant, your bank. So you would put your bank's name in there and your name where it goes in name. And if you guys want a copy of this TRO, you can send me a message on my Facebook group page asking for a copy of the template. I have them available and I can email these to you if you need these to look through and use. I also have them in Word and in PDF. Okay, so the next section is parties to the action. The plaintiff is John Doe, which would be you, and resides, and you put your address there. The defendant is your bank, is a mortgage loan servicer and debt collector and located at, and you put their mailing address there. Background, the transactions and events which are the subject matter of the TRO occurred in your county, state, your state. The subject property giving rise to the lawsuit is known as, you put your mailing address there. The plaintiff or plaintiffs, or if your husband and wife are single, reside at the property as their permanent and sole residence. The legal description of the subject property in relevant describes it as, and then there's a legal description, you want to insert that there. You can find the legal description usually on your deed, mortgage, or note. Legal description. Okay. Factual allegations section's next. So this is just to give you an example of what some people might put. The first part you want to put, kind of give them a background. The plaintiffs first purchased their home at your address on this date. The amount of the loan was for, you can put the amount of the loan, amount borrowed. Plaintiffs pay their monthly mortgage payment to, you can put the servicer's name there. The servicer on the statement shows the payment to be mailed at, you put the mailing address that you mail your payments to. And the loan number is, you can put your loan number. Defendant, your bank or servicer, scheduled a notice of trustee sale on the plaintiff's property. The sale is scheduled on, you put the date of the sale, for collection and the amount of, you can put the amount they're trying to sell it for. A copy of the notice of trustee sale is attached hereto as Exhibit A. So you definitely want to attach this to your TRO. Plaintiff does not owe the amount that the defendant states is owed. Now you can, if that's the case, then you can put that, and you can put other things as well. These are just some examples of things people will put on their TRO reasons. The plaintiff asserts that the alleged debt that the defendant is trying to collect is also time barred. Any other reasons you want to list here why the sale should be stopped. The plaintiff's home is worth approximately, you can put any amount there of what you think it's worth, and therefore has equity in their home which would greatly harm the plaintiff if this sale continues. Defendant has harmed the plaintiff by charging excessive fees, not crediting payments to the loan, returning payments in order to cause the plaintiff to default on the loan. I mean, this has happened to a lot of people. We can all pretty much say that a lot of servicers do this in order to push you into foreclosure. The plaintiff has been harmed by the defendant's refusal to grant a loan modification or any other reasons that you can think of. You put them there. You could say that during the COVID crisis, your account was placed on forbearance and the amount was put in deferment, which is now a big balloon at the end, or whatever else you can think of regarding your situation. But a lot of this is in the accounting, guys, so if you're smart, you'll look through all your statements that your servicer has sent you and try to find problems that they may have caused you and that you may not even been aware of. Anyway, so the last part of this, basically you want to say plaintiff should not have to post a bond in this situation as the defendant, your bank or servicer, has and will not suffer harm as a result of stopping the sale. Alright, prayer for relief. Wherefore plaintiffs pray for the court to issue a TRO and preliminary injunction against the defendant and order the trustee sale stopped. Respectfully submitted, your name and date. Okay, then you want a verification. This is on the next page. You want to put the name of your state and the county. I have read the foregoing petition for a temporary restraining order, TRO, and preliminary injunction and know its contents. The matters stated in the foregoing document are true of my own knowledge, except as those matters which are stated on information and belief, and as to those matters I believe them to be true, I declare under the penalty of perjury under the laws of the state of your state, and the foregoing is true and correct. Alright, and then you just sign it and date it. And that is, oh yeah, certificate of service. Forgot about this. You don't want to forget this, guys. Basically, it's a statement stating, I hereby certify that I am over the age of 18 and I have sent a certified copy of this petition for a temporary restraining order and TRO or preliminary injunction to the following defendant. Your bank or servicer, and their address goes there. You sign it and date it. And so the other side has been served then. Now, you also need to do a lis pendens. Let's look at the lis pendens real quick too. Okay, so the lis pendens is you use the same kind of heading at the top. Any court in the United States in your county. You want to put your name, the defendant's name, and put Liz Pendens at the top, and a place to put a docket number for the case number, because you'll do the Liz Pendens after you get the TRO, so you can actually have a case number to put in there. That's very important that you put that case number on here, guys. So it just says, to whom it may concern. Notice is hereby given of the commencement and pendency of a suit in the, and the name of your court goes there, entitled as above, docket number, and general, TRO or complaint, whatever you put in there. If it's a TRO, then you want to put temporary restraining order. If it's a complaint that you want to file instead of a TRO, then you would put a complaint there, of which involves the title of the property owned by, you put your name there, described below against a deed of trust or mortgage. If your deed of trust state, it's non-judicial. If you're judicial, it's mortgage. Recorded within the office of the Recorder of Deeds, your county, whatever county you live in, and the name of your mortgage company you are suing goes there. It is recorded in, you got to put your plat book, page number, instrument number of whatever your deed has on that mortgage, and holds title to your subject property recorded in the office of the Recorder of Deeds in your county. So this goes to your deeds office. So there's a legal description that goes there, and my friend let me use hers. That's what hers looks like. And then you put your name and address there, and you take it and get it notarized before you file it. And that's it. You just so you guys know this, the TRO and the Liz Pendens, you do the TRO first and the Liz Pendens second. Okay, guys? If you want to file a complaint in court, however, you can do that and stop it as well by doing the same thing. File a complaint in court and Liz Pendens. That will also stop the sale. Now, as far as the bond and stuff goes, guys, people sometimes go to federal court and they have a really long and involved complaint, which I have on another video. If you guys have any questions about this, or you need any of these templates, look, just give me an email or a text message on my Facebook page. I hope everybody has a wonderful Thanksgiving, and leave any comments. Okay, y'all have a blessed day.